NACDL is the association of the nation's criminal defense bar.
Thank you for inviting me. I'm Andrea Harris. I'm an assistant federal public defender from the Western District of Virginia. Thank you for inviting me because it's a very important topic, but also thank you for inviting me because it gave me an excuse to visit my sister in State College last night. So I am far from an expert on these cases, but the Western District of Virginia has very aggressively prosecuted these cases and is getting more aggressive by the moment. So I just hope I can kind of alert you to some things to be on the lookout for. First question, though, how many of you practice in federal court, if any of you? And how many of you have handled one of these distribution resulting in death in federal court? So a few. So those of you will then recognize the building there on the left, which is the Ronald Reagan Federal Courthouse here in Harrisburg. At least according to Google it is. And the building on the right is the United States Penitentiary in Lewisburg, Pennsylvania, just up the road. So oftentimes when you're dealing with one of these cases in federal court, if your client is in the building on the left, there's a good chance that he's going to be in the building on the right, or one very similar to it for a fairly significant period of time. But hopefully we can help avoid that or at least mitigate that. These are some commonly used federal drug statutes, just to give some of you who don't practice in federal court a little bit of a primer. Section 841 is the main federal drug statute, prohibits the manufacture, distribution, dispensing, or possessing with intent to do so. And then Section 960 relates to importation and exportation of drugs. Under federal drug laws, the minimum and maximum sentences are driven by the drug type and the drug quantity. And depending on the drug quantity, if it's alleged in the indictment, it increases the mandatory minimum sentence from 0 to 5 to 10 years. The government also has the option of filing sentencing enhancements under Section 851 that will increase those mandatory minimums if a person has a prior conviction for a serious drug offense or for a violent offense. So in addition, the government can enhance sentences if the distribution resulted in death or serious bodily injury. And in every case, if the government seeks this enhancement by alleging it in the indictment, it takes the mandatory minimum sentence from in any case to 20 years. And in federal court, there's no suspended time. 20 years means 20 years. If there's a prior serious drug offense conviction or a serious violent offense, then the sentence, that 20-year minimum, can be increased to life. Obviously, I'm going to talk just about the enhanced penalties for death and serious bodily injury today. The elements of Section 841 are pretty similar to the elements of under the Pennsylvania statute. The mens rea is knowing and intentional, and the government has to prove that the defendant had knowingly and intentionally distributed a controlled substance. If a quantity is alleged, they have to prove that beyond a reasonable doubt. And if death or serious bodily injury is alleged, they have to both allege both of those things in the indictment and prove them beyond a reasonable doubt in order to trigger the mandatory minimums. One area of difference between the federal statute and the Pennsylvania statute is that the federal statute also punishes serious bodily injury as opposed to just death. So serious bodily injury is defined in Title 21, United States Code Section 80225, and it's defined as creating a substantial risk of death and or protracted or obvious disfigurement or protracted loss or impairment of the function of a bodily member, organ, or mental faculty. Substantial risk of death is essentially if a person overdoses and has to be resuscitated by Narcan, the courts have held that that is sufficient to qualify as serious bodily injury. So the person can overdose, rescue squad is called, they can be given naloxone, they can completely recover, be perfectly fine, and the government can still prosecute the distributor of the drug with a mandatory minimum sentence. And in the Western District of Virginia, in fact, they do that. Not quite as often as with death cases, but unfortunately that is something that they do on a not infrequent basis in my district. For those of you who practice in federal court, just be aware that there's slight differences between the definition of serious bodily injury under the statute and under the sentencing guidelines. It's not a real significant difference. Instead of substantial risk of death, it's extreme physical pain or requiring medical intervention. So they're just slight differences. I don't think ultimately they will make a big difference. A couple other issues I'm going to talk about are causation, as Brian mentioned, joint possessor defense, and then charge bargaining. So by now, I'm sure most of, if not all of you, are aware of Burrage v. United States. This is the 2014 Supreme Court case that defined the results in language from the distribution resulting in death federal statute. In Burrage, Marcus Burrage distributed 1 gram of heroin to Joshua Banka. Joshua Banka was a longtime drug user who was on an extended drug binge. Used, in addition to the heroin, he had used oxycodone, Xanax, clonazepam, among other things. And in that case, the medical examiner determined his cause of death to be due to mixed drug intoxication. And at trial, the forensic toxicologist testified that he or she, I can't remember if it was a he or she, but testified that they couldn't say whether he would have died without the heroin, but that the death would have been substantially or significantly less likely. Obviously, he was convicted. In this case, the instruction was if the jury found that the drug that Mr. Burrage distributed contributed to the death, that was going to be enough. So obviously this is the issue that then reaches the Supreme Court. And the Supreme Court in Burrage has a lot of talk about causation just in general, and talks about causation being a hybrid concept consisting of 2 constituent parts. The first is actual cause, and the second is legal cause. And what the Supreme Court says is when a crime requires not merely conduct, but the result of the conduct, a defendant generally may not be held liable unless the conduct is both the actual cause as well as the legal cause, which is often referred to as proximate cause. So in Burrage, the Supreme Court granted cert actually on 2 questions addressing both of these issues, actual cause and proximate cause, and then reached the first question, the actual cause issue. And so this is the holding of Burrage. At least where the use of the drug distributed by the defendant is not an independently sufficient cause of the victim's death or serious bodily injury, a defendant cannot be liable unless such use is a but-for cause of the death or injury. So that standard seems to be obviously the same as under the Pennsylvania statute, although I think the feds are much more clear that contributing to the death is not enough under federal law. I have a couple slides to illustrate actual cause and but-for cause. These slides are courtesy of Angela Campbell, who is actually the attorney for Mr. Burrage himself. So this first slide is actually pretty simple. Actual cause is easy to understand. In Burrage, Justice Scalia set out several examples to illustrate these different concepts of cause. And with regard to actual cause, he gave the example of A, shooting B, who is hit and dies. A actually caused B's death, since but for A's conduct, B wouldn't have died. So this one's a fairly simple concept. But for cause becomes a little bit more complicated. There must be proof that the harm would not have occurred in the absence of the conduct. That is, but for the defendant's conduct. And so Scalia, with regard to but for cause, gives the example of if poison is administered to a man debilitated by multiple diseases it is a but-for cause of his death, even if those diseases play a part in his demise, so long as without the incremental effect of the poison he would have lived. But for the amount the defendant distributed, no death. This one, so this is the holding of Burrage. When you read it like that, it's not a very defendant-friendly way of looking at the holding in Burrage. And I'm going to kind of talk about that in a second. But that is Justice Scalia's kind of illustration of but-for cause. And then finally, we have independently sufficient cause, which is also referred to in their holding. And the example given here is that where A shoots B at the same time that X stabs B, and both the shooting and the stabbing are fatal wounds, either would have been sufficient to kill. And so that's an illustration of that. But the bottom line is that it's not enough for the drug to have contributed to the death. The government's always going to try and frame the argument as, well, without the heroin, he would have been perfectly fine. The Xanax didn't kill him, the heroin did. But the Supreme Court also has this language in Burrage. And it says, the language Congress enacted requires death to result from the use of the unlawfully distributed drug, not from a combination of factors to which drug use merely contributed. So I think this is how we want to try and frame the issue, that we can't say that he would have died with only the heroin because, there's all these other factors, tolerance, how much he used, all these different things. So we want to say they can't prove that he would have died with only the heroin, but because of the synergistic effects of heroin and the Xanax or whatever other drugs are in the system, heroin just contributed to the death. So whenever possible, and obviously this is only possible if you have a multiple drug intoxication kind of case, but try to frame the argument as that the death resulted from a combination of factors to which your client's conduct merely contributed. This is obviously going to be a better issue for for a jury instead of a judge, because given Justice Scalia's illustration, I don't think many judges are going to be quite on board with the argument. But speaking of juries, this is a jury question from a distribution overdose case that I had, and the question is this. We have a question regarding whether death results from the use of heroin means solely from the use of the heroin, or that the heroin contributed to the death. And so after Burrage, the answer to this would be very simple. The answer is no, that contributing to the death is not enough. In this particular case, the medical examiner testified that the heroin was the only cause of the death, that this particular decedent had heroin and Xanax, pretty high levels of both in his system, but the medical examiner testified that it was only the heroin. Keep in mind that medical examiners and toxicologists are not your only available options for causation witnesses. Lay witnesses can also testify to facts surrounding the events that I think may be persuasive to a jury. In this particular case, the girlfriend of the decedent testified that the decedent was a very long-time heroin user, used significant quantities of heroin every day for many, many years, but that in the very recent past, he had begun injecting heroin and Xanax together, and that when he did that, he fell out and had to be resuscitated essentially every single time. And so despite that, the medical examiner still insisted, no, it was only the heroin. But the jury, I think, found that significant, because this is the question that was asked. Unfortunately, this question was asked while Burrage was pending, and so the court didn't answer the question. And the jury ultimately found him guilty. The Fourth Circuit affirmed the conviction 2-1. I think if this question had been asked after Burrage and the jury was properly instructed, I think it probably would have come out a different way for the defendant in this case. Multiple drug intoxication, I think, is something that comes up very often in these cases. Many, if not most, overdoses involve multiple substances. This is just a chart of overdose statistics in Pennsylvania. These numbers are taken from a DEA bulletin from September. In 2018, there were 4,491 deaths, overdose deaths, which was down 18% from the year before. But in 70% of the deaths, fentanyl was involved, heroin was involved in 35%. And you see from that chart, if you add that up, it adds up to 189%. So it's not a perfect pie chart that adds up to 100%, but that's because, many of these deaths involve more than one of these substances. I thought it was significant that 28% involved benzodiazepines. And so, as in that case that I just talked about, take a very careful look when you have cases involving opioids and benzodiazepines, and really make sure you talk to forensic toxicologists and medical examiners about the interplay of those two drugs in particular. So back to Burrage, the second question that they granted cert on was on the proximate cause question. The second question presented was whether the crime of distribution resulting in death is a strict liability crime without a foreseeability or proximate cause requirement. Now, they didn't answer this question because they granted the first question in Mr. Burrage's favor, so they didn't have to reach this question. But I think it's an important issue to keep in mind and to preserve the issue if you have any of these cases. The U.S. v. Hatfield case is a Seventh Circuit case from, I can't remember what year it is, it's in the materials, but Judge Posner has a long discussion of proximate cause, kind of a law professor discussion of proximate cause, causation in general, but also proximate cause, and it's worth a read. Now, just very recently, the Seventh Circuit, in a recent opinion, said, all the stuff that Judge Posner said about proximate cause or causation and proximate cause is just dicta. But I think it's still helpful to take a look at that case if you have any of these issues. In 1994, in the Fourth Circuit, which is where I practice, the Fourth Circuit held in United States versus Patterson that the plain language of Section 841 does not require a finding that death resulting was a reasonably foreseeable event, and that essentially the statute puts drug dealers on notice that if people are harmed by the drugs that they distribute, their sentences will be enhanced. So that was 1994. In 1999, the Third Circuit here in your area adopted the reasoning in United States v. Robinson, and essentially they said that the statute is plain and unambiguous and does not require proof that the defendant knew or should have known that death would result. This is a 1999 case, but was recently affirmed in an unpublished opinion, U.S. v. O'Brien, here in the Third Circuit. So you can ask for jury instructions on this. You're not likely to get it here in the Third Circuit, but I would definitely preserve the issue. In 2016, there was another case that the defendant lost on this proximate cause issue in the 10th Circuit, U.S. v. Burkholder. But that one was interesting because it was a 2-to-1 decision, and the dissent said that the dissent was not convinced that the results from language unambiguously reveals an intent to forego the proximate cause requirement by Congress. So, I don't think it's a, completely done issue yet. And this interpretation of the results in language is inconsistent with the interpretation of similar results in death language for many other federal statutes. So I would definitely preserve this issue. Some of those other cases are cited in the materials. But ask for an instruction, try to get an instruction. Burrage granted, the Supreme Court granted the issue in Burrage for a reason, and so I would keep trying to preserve this issue. One thing I want to just talk about quickly, this is not included in the materials I've submitted, but I've been working on this on a case I currently have pending. And it may come up more often than you think, because in so many of these opioid cases, you have one drug user who's just trying to get enough drugs to get his or her next fix, and he's often going in with a friend. They get drugs together. They're either pooling their money or they're going together to get drugs. So I think that this could be potentially an issue in some cases. The main case on this is the United States v. Swiderski from the Second Circuit. It's an old case from 1977. And that was a case where an engaged couple was out. They met with an informant. They both agreed to get cocaine from the informant. And then they were ultimately charged in federal court with possession with intent to distribute to each other. And so they argued that they weren't trying to distribute to each other. They were just jointly possessing the drugs. They were obtaining the drugs together. And so the Second Circuit held when two people simultaneously and jointly acquire possession of a drug for their own use, intending only to share it together, their only crime is simple possession. And then they list some factors that to consider as whether this kind of inference should be made, such as the nature of the relationship, whether the nature of the relationship between the parties is personal or commercial, the quantity of drugs, whether the drug is a user amount of drugs or not. This argument was unsuccessful in a case where a guy was driving back with 12 grams of cocaine, and I think there was an inference that perhaps that was more than just a personal amount. The number of people involved, and any statements and conduct of defendants. This case is old, 1977, but it was cited very favorably recently in 2016, again in a Seventh Circuit case. So perhaps the Seventh Circuit is a little bit more friendly than some of our other circuits. Many courts, federal courts, as well as state courts, have considered the issue. A lot of them, I haven't really seen any that have rejected Swiderski completely, but many will try to just cabin it into its very specific facts. And so they will, there are holdings that say if I went and got the drugs and brought them back to my friend, that is different, and that doesn't meet the simultaneous and joint acquisition of the drugs. There are a couple cases, though, where a person goes off and gets drugs and brings them back and they use together that have the joint possessor defense has worked. So I would definitely take a look at that if you have any. I couldn't find any Third Circuit or Pennsylvania cases on this issue. I've been working on it on a case I've got pending, so I have a list of cases. I'm not sure it's an exhaustive list yet, but if this issue comes up in any cases you have, feel free to contact me, and I'm happy to share what I've gotten, at least so far. In federal court, this is charge bargaining is basically the name of the game. Unfortunately, we don't have a lot of trials in federal court on these cases for two main reasons. One is most defendants don't want to take their chances at a 20-year mandatory minimum. So even if they have good defenses, they're oftentimes very afraid to go to trial and risk a conviction and a 20-year sentence that the judge would have no ability to do anything about. And then the other thing is that the feds get to pick and choose what cases they take. So they're not generally going to take the cases where there are a lot of substantive legal issues. So in the Western District, historically, we have, even in these cases where we haven't had much to argue, we have had some luck in getting the government to agree to allow the defendants to plead to lesser included offenses of just straight distribution. Most of the time in the Western District of Virginia, that involves a Rule 11C1C plea agreement to either a fixed sentence or a fixed sentencing range that is generally significantly higher than what the person would have gotten if they were just convicted of distribution. But of course, it's better than a 20-year mandatory minimum. It's also, I think, helpful if you can avoid the distribution results in death conviction, and particularly in fentanyl cases, but just in general, because under the First Step Act that was passed last year, there are a number of additional rehabilitative programming that the Bureau of Prisons is supposed to institute, and that will allow prisoners to have extra earned credits. And there's lots of carve-outs under the statute for people who are not eligible for these, but if death results, that's generally a carve-out that would make some of these defendants ineligible for some of the extra programming and rehabilitative programs that are supposed to be instituted under the First Step Act. The last thing that I will just touch base on is in March of 2018, then Attorney General Sessions issued a memo encouraging United States attorneys to use every available criminal remedy in drug-related cases to combat the opioid epidemic, including the death penalty. And as far as I know, this memo has not been withdrawn. This is still the guidance given to U.S. attorneys. When this came out, I was kind of shocked. I didn't even realize that the death penalty was an option. But apparently under 18 United States Code 3591, there are provisions that the government can seek the death penalty. These are cases that involve pretty high levels or high quantities of drugs. I think 60 kilos of heroin, 24 kilos of fentanyl, or 6 kilos of fentanyl analogs. As far as I know, the statute has never been used before. It's likely unconstitutional, but I just wanted to be aware because in case you think things cannot get worse, oftentimes in federal court they can. So I just kind of give you some of this information, particularly for those of you practicing in state court. If you can avoid having the feds adopt your state case and keep it in state case, even though it seems like things may be getting bleaker in state court, they're not nearly as bleak as they are in federal court. Thank you.